My job is that they sign the form that says that they do the thing, right? That's what I want.
Handling of consumer data is a murky area in our auto industry with emerging technologies, especially in our retail technologies and rising regulatory scrutinies. Dealers find themselves, well, they're struggling a little bit to navigate these compliance oversights and risks from vendors who honestly just flat out refuse accountability. And something has got to give. Welcome into Facts Not Feelings. I am your host, Brooke Furniss. In this episode, we are shining yet another light and doing yet another episode on compliancy and data privacy. And we're trying to navigate those landmines of the Gramm-Leach-Bliley, simply known as the GLBA Act, which we've done. I know we've done a couple shows on this, but April, you reached out to me and we said, we got to do another episode on this because we've got to dive in this once again. And not just on that portion of it, but diving into those outdated lead transmissions, and you're thinking to yourself, what is that? The ADF XML portion of it. How does this impact your operations, your revenue, and even, like I said, your reputation? Let's dive in and find out. I am joined by three special guests today and their unique vantage points into this super thorny issue. First and foremost, we have Brian Pasch. He is the founder of PCG. He works hand in hand with dealers on marketing compliance and so much more. We have April Simmons. April Simmons is the corporate marketing director of Horn Automotive, Horn Auto Group. She is out in Arizona and a very dear friend of mine. She is constantly grappling with this centralized data and trying to hold people accountable. We have Tom Kline, who is the former dealer, and he's also an industry expert of consulting and helping dealers overcome vendor hurdles. Brian, I'm going to go straight to you on this one. We're going to start out with saying, how has GLBA changed the way that dealers need to work with vendors, manage customer data, and then follow that up with what's compliance advice do you have for dealers?
Yeah. Hey, Brooke, thanks for inviting us on the show to talk about this important topic. I think the GLBA has made a new requirement for dealership management. And this requirement is you need to understand the path in which your data flows. Honestly, before these regulations, dealers just saw information come into their CRM. The average general manager didn't understand how it got in there, whether it was through an API, an application program interface, which is a secure digital link, or in the clear data file, which we call the ADF, Automotive Data Format, ADF, which was designed in the year 2000, 23 years ago. And this is an unencrypted open file format, which would be sent via an email listener into the CRM. And this not just only applies to how data gets into the CRM, but is how are people taking data out of my DMS or out of my CRM? Marketing agencies, it's not uncommon for them to say, hey, do a dump from your DMS and email me that file for marketing this month. These new requirements are forcing a new line of inquiry for managers. How is my data moving to my marketing agency? How is the data coming from my website to my CRM? Who has access to my DMS and how are they moving? When dealers start asking these questions with a higher level, is this data secure? When they probably find out 70, 80% of those transfers are not, here's the warning, and I hate to be a doomsday, and Tom, you know this better. When Lithia got fined a number of years ago for texting, it sent a shudder through the entire automotive industry. No one wanted that $1 million fine. And what did people do? Let me fix my texting. I got to find out who's texting. And okay, when a few dealers get sued for data privacy violations, it's going to send a huge ripple. People will start scrambling. And this is not the first time you've brought this up, Brooke, on your show. A Unfortunately, I think the vendor community is dragging their feet. Dealers are dragging their feet. It's going to take some lawsuits and some fines to get people to put a sense of urgency behind this.
Amen to that one. Tom, I'm coming over to you next on this one. GLBA, it's pretty cut and dry on this. They lay out clear obligations for dealers when it comes to data privacy and security, but for some reason, there are vendors out there. I'll just leave it at vendors and fill in the blank on if you want to say vendors, whether you want to say partners, whether you want to say whatever you want to fill in the blank, but let's say companies that have been slow to step up. I'm just going to let you take it from there on that one. I'm just going to say ... fill in the break there.
Yeah. So, yes, they have been slow to step up. Yes, they're having a problem, and they don't want to reinvent the wheel, which is part of the problem. As Brian brought up the ADF XML format, somebody's gonna have to come up with a new standard. Maybe Brian can do that and come up with the new standard and roll it out to the whole automotive community. And dealers are required, according to the regulations, if their vendors, partners, whatever you want to call them, aren't complying, as April, I'm sure, is going to get into, if they're not complying, dealers are required to replace them. Now, that's a twofold thing. Number one, you can't go from the frying pan into the fire, right? Because you can't go from one non-compliant vendor to another one. So that doesn't help you. So the question then becomes, what can you or what should you do? And it's now a good time for me to give the dealers two things I think they should do.
To have at it, man.
Two things. I've got two things. Neither are magic bullets, but I think it's the best that you can do. First, consider some customer data platforms will provide encryption. So you can send your data from your website into the customer data platform, and then when you receive it, it is encrypted. Now, those aren't perfect. They don't go with every vendor, but I think that's the very best that you can do to try to comply. The second step, I would say, alongside that is to document your communications, make sure you have very good records, call every 2 months, send an email so that when the regulators come in, or if they come in, because remember the fines are $50,120 per violation. Now, the FTC didn't define what a violation is on this. And the reason I think they didn't define it is because they want the flexibility to enforce it as they see fit.
That's right.
So if you get 20 leads, is that 20 violations? Nobody knows. And I think it's going to take the fourth or fifth dealer to get pegged before anybody wakes up and realizes this is a problem. If the first one is an anomaly, the second one, whatever. The third one, 3 strikes. After the third one, people are going to be, oh my God, what's happening here?
Yeah. And Tom, I want to reiterate this paper trail. I think that the FTC will obviously go after the people they think have the biggest pockets. And the biggest headlines, which would be the publics for sure, and any very large private group, because they know that's where the ripple is.
Sure.
But one of the things that I believe, since this is relatively new, if a dealer or a dealer group has regular communication, like we need a solution, I need a deadline, I need a timeline. If you don't provide a timeline, I'm going to have to switch vendors. And there's that communication going out. Then I think that's a huge mitigating factor on whether or not there was deliberate or willful ignoring of the law.
That's right.
But
the willful part is the important part, right? If you're willfully non-compliant, they're going to hammer you. If you
what about how do I fire an OEM? I mean,
great
point.
Well,
because we're not getting back to us either.
I think, April, you have to continue to document. I think you have to make sure that, hey, every month I called or I had somebody call and say, where are you on this? Because when we punch out, right, when you punch a warranty ticket, right, you're transmitting PII. There are so many, when you RDR a car, you're punching PII. There's so many interactions with the OEMs that should be encrypted that I know aren't. I haven't really heard a whole lot. I think Toyota's making some noise about encrypting from what I've heard. But the other manufacturers, I really haven't heard much.
You know, Tom, to April's point, and I think April's good point, one of the opportunities as an influencer in the automotive industry, people listen, right? I just published an article this weekend on Capital One, which is, here's an example of dealers not even knowing that PII data was being siphoned off their website for some other party's use. Tom, it may be helpful for you and me maybe to get together and to look at the current ways in which the DMS is communicating with the OEMs. I know there's a STAR standard, which is a data exchange format. I thought that was encrypted, but it may not be for all communications. But that being said, it may be good to create a table or a graphic that shows the dealer to OEM communications that are unencrypted and basically say, hey, as we interpret the Gramm-Leach-Bliley Act, these systems have to be resolved. I think that once we put the OEMs on notice, this is the key, not a dealer, but when the automotive industry addresses from an expert view, this gives April, hey, did you see the thing that Pasch and Kline put out, which was a table of the systems that they believe are putting dealers at risk, and half of them are managed by OEMs.
Yeah.
Or Shift Digital, for example. You know, once that gets out there, I don't think anybody wants to be on that list. You know what I mean, Tom? So maybe it's sometimes public shaming. And in this case, public education means that April has more than her own, feeling like, why would an OEM listen to April Simmons? They have other things to do. But when it starts to get read by 30, 40, 50,000 automotive professionals on LinkedIn, guess what? Then legal folks and compliance folks, believe me, Capital One's legal team has reviewed that article. I've already gotten emails from other banking people saying I was too easy on Capital One. People are reading. So maybe that's what we have to be, Tom, is specifically call out the CRMs that are sending data in the clear, the websites that are sending data in the clear, the service marketing people that are taking data in the clear. You know what I mean? Like maybe we just have to list them out and say, if you're doing any of these things, you're at risk.
Which I absolutely love that. And I just want to take this a step further in one of the dealer's main pain points and why this is so frustrating. Early on, NADA published, FTC guidelines for the dealers for us to follow, to make it easy, checklist. And my group, we don't want to be one of those that get sued, right? We don't want to get the fines. We don't want to go through that process. So we early on created a team. We have sat down and we dissected it down and said, okay, is this technical? Is this, what aspect does this fall under? And we divided and conquered. And we've done a really good job, and I think we've gotten massive headway. But let's face this was supposed to be done last December.
Yeah.
And then they kicked the key into June. And here we are all sitting here months later. We're knocking on a year now, and we're not getting movement. And I just want to read one aspect out of the guidelines to lead this in so that I'm saying the exact verbiage. Under the 2003 rule, you are required to oversee your service providers by taking reasonable steps to select and retain service providers that are capable of maintaining appropriate safeguards for protecting customer information, and 2, obligating your service providers through contract to implement and establish such safeguards. The revised rule also requires that you periodically assess your service providers based on the risks they present and the continued adequacy of their safeguards. That is, you should take steps to ensure that your current service providers maintain adequate procedures to protect customer information and detect and respond to potential security breaches. Okay. The next piece specifically says who qualifies as a service provider. The revised safeguards rule maintains the current rule's definition of service provider as any person or entity that receives, maintains, processes, or otherwise is permitted access to customer information through its provision of services directly to a dealership. Okay? So, unpacking that, I now am going down the rabbit hole of all the people, all my service providers that I now need to, through contract, have them tell me, yes, April, we are compliant. Great. I start the emails. Hey. I'm going to tell you as I sit here today, 60% of them have just straight ghosted me. Can't even get a response. The next layer of them are like, oh, wait, I don't even know what you're talking about, April. Let me find out who. And so my true vendor partners who are saying, hey, okay, we want to help April out. Let's go try to find the person in my organization who should be the person doing this. And some of them, we've gotten some result, right? We've gotten those things handled. But then I have another probably 30% of people who flat told me, yeah, April, you know what? We're compliant, but we're not doing nothing. We're not.
Yeah.
We're not.
And April, and one of the little shades of gray, and Tom, I'd love your opinion on this. This sounds like in the weeds, but it's really not. Some vendors have secure RCI certification or secure CDK certification to get access to the DMS. And what their software does is extract the data. Now, if they're not passing that data securely to their marketing automation platform or to their mailer, if they're effectively using the RCI interface to dump a flat file inside their organization and then internally leaving that file unencrypted on a server or emailing it to another department or emailing that file to the mail house, and this is where it gets a little hard, it will be very difficult for a dealer to have the right questionnaire to say, do you have access to my DMS? Yes. Are you going through secure? Yes. What are you doing with the data from the DMS? How is it being transported to your mail house, to your email house? And that's where I'm afraid that some of the people you're dealing with don't know because they're not in operations, but yet you're probably required to have them answer that survey and send it back to you signed, that at each, if they're a service marketing company for you, or if they're a digital marketing company for you, I think somehow there has to be a very tactical checklist that they have to respond to, Tom, and this is where it gets hairy. If they don't respond to the survey, isn't what April is basically implying that if they won't respond, she really has to go find somebody else?
And I'm going to tell you, Brian, I'm not going to bus roll a bunch of people, but the person that you did an article on this weekend, they are one of them that have flat told me that they don't have to sign anything, and they do not have to do my check sheet.
Well, Capital One is a unique person who, again, I don't know their intentions, but quite a bold installation of their CDP without dealers' knowledge. They are collecting data on a dealer's website. And from what I understand, Tom, right, it's the dealer's website, the consumers who goes to a dealer's website and fills out a form, they assume, and I think that's the responsibility, that they're doing business with that dealer. Now, what Capital One does with their data in that form impacts the dealer's requirements, because at least the way I read it is when a consumer fills out a form, they must disclose where that data is being shared. If the vendor's form isn't saying, hey, it goes to Capital One and an open lender's marketplace and we sell these leads, then the dealer is ultimately responsible.
And then, Brian, it goes another level because you also have Leads Navigator, and I don't want to bust on everybody, but I'm just going to use them as a good example. They have Leads Navigator. So they're also sending to my CRM PII.
Exactly. Yeah.
Right?
They're going to CRM. That's CRM.
Social security number. They're sending information. They're sending PII to me. So at the same token, there's this like, what is the law really saying? But at the end of the day, there's data flowing from me and to me. And I'm basically being told, we're compliant because we're a bank, which is why they're a good one for me to have this conversation about. Because
listen, if they're sending a lead file in ADF XML format, which is clear text, using an email listener, then that's not compliant. If they've worked with eLeads and VinSolutions and DriveCentric to use their API, and some of them don't even have stable APIs, and Capital One is sending that data of secure API, but if they're sending ADF, there's absolutely no way anyone could say, because remember, the CRMs were built as email listeners, and an attached file in an email listener is not an encrypted file.
Correct. So I'm going to just call it out then now. This is going to sound horrible. I don't even care because you know what my job is? My job is that they sign the form that says that they do the thing, right? That's what I want. But here's what I also know based on everything you just said. There's a reason that they're not. There's a reason that I'm not getting any proper movement forward is because the real fear is what happens when all these dealers get fined? Can they now go sue somebody? Well, if they didn't sign a form, sorry, we're so sorry. That's the real fear. We get into this thing of pointing of fingers and rolling uphill, downhill, and all of those things, when at the end of the day, I'm just trying to do what it says my responsibility is. Because let's face it, dealers are never going to fully know and understand the layers, right? We're not going to understand how data flows and all the acronyms and all the different things. That's just too much to even think a dealer will know. That's why the dealer's responsibility is to have the vendors and vendor partners sign that they are and do these checklists that says, we are this, we are this, we are this. Because dealers, we're never going to know. But if the vendors are unwilling to even come out and forthright say, send me the sheet you need me to sign, tell me where I need to go to fill out, my checklist. That to me is the number one pain point right now. And if you're in that middle space where you're really not sure if you're supposed to do this or not, fine. But if you have direct access to a DMS or a CRM, you definitely need to comply.
Or on the back end of the website. That's another one people don't forget. Because for me, I might have access, but even back in the website. So Tom, I'm going to take a question over to you real quickly. For those vendors, we're talking a lot about this, but for those vendors that are claiming they don't need to comply with GLBA, because we've talked about this a lot, they don't need to comply with GLBA when it comes to, especially with this ADF XML portion of it, or we're already doing it, but they're not going to sign it. What are the legal risks? Because this is where I know this is just a small portion of what you do, but you kind of become that everyone ask Tom. So what are the legal risks that the dealerships are opening themselves up to, or the company? What are these risks?
Yeah, remember my disclaimer is I'm not a lawyer. I just talk like one. So I'm a former dealer. So from a dealership perspective, let's just pick on any one vendor. Let's just say that your CRM vendor isn't complying. They're not going through an API, and you want to know what if, right? I espouse making sure you think about what if in your dealership. What if this happens? What if that? So what if the FTC comes in on your CRM? Well, the first thing you should do right now as a dealer is look at your agreement and what your agreement says right now. Because likely your general sales manager signed the agreement and didn't make any changes. So what that agreement probably says, because nobody read it, nobody has a copy, and what that agreement says is that the dealer is going to indemnify the CRM vendor. That's likely because the CRM vendor's attorneys put together a form. The CRM says, yeah, nobody ever reads it, and they just sign it, and off we go, right? And what that says 99 times out of 100 is that the dealer is going to indemnify the vendor, which is exactly backwards, right? That's backwards. So if the dealer gets fined and he says he gets fined because the CRM vendor, the dealer's going to want to take legal action against the CRM vendor, right? Well, what it's going to come down to, in my opinion, not a lawyer, and from a business guy's perspective, it's going to come down to what that agreement says. And if that agreement says the dealer is indemnifying the CRM vendor, then the dealer's stuck. That's part number one. As a dealer, I think the dealer body does a brilliant job at controlling what they can and letting go of what they can't. And so in this particular case, I want to emphasize the dealers, I don't think this is something to obsess over, but they need to get this straight. They need to document what they're doing. They need to make sure they're not going to get tagged for willful noncompliance. And in this particular case, you have to think also about the insurability. Are these fines and penalties insurable? So if I'm running a dealer group and I am concerned about being fined, what can I do about that? Well, there is an answer to that question, which is directors and officers insurance often will cover the peril of a regulatory fine. So when you're thinking about how you're complying or trying to comply with all this, I would emphasize to make sure to try to cover your backside to buy D&O insurance. Look at the definition of what a claim is. That's really kind of where the rubber meets the road on this. What is a claim? And in most D&O policies that I've read, it goes through and says a regulatory fine or penalty is a claim. So if the FTC comes in, you turn it over to your D&O carrier, and you're covering your backside. So D&O.
Tom, would it be possible? And again, I'm not a lawyer. I just don't like them. But
I'm not either.
Tom, if a dealer practically is operating in today's environment, they've been exposed to this. I think it's probably likely if the E&O policy, errors and omissions for a director's policy, if they come in and research the claim and say, you were aware of this, you never sent out letters to your vendors, you never did this, this, and this, they may deny the claim because it was willful negligence. If the dealer did send out the letters and then to the OEM and saying, look, I did all I can, and gets fined, then the insurance company says, look, they were aware, they escalated it, they've gotten no help from their manufacturer, they're limited to a franchise dealer agreement that is requiring them to use these systems. I mean, that to me is a better thing. So just having the insurance and ignoring what I would say their part may weaken the coverage of that insurance policy. That's just the way I in my past dealing with insurance.
Well, in insurance policies, as I like to say, they don't have stupidity clauses most of the time. So even if you're stupid and you do something stupid, that doesn't let them off the hook for whatever the policy says. So you have to, the trick is you have to read the policy and know what they say. So right. It's policy dependent. But I don't think, if what you're saying, I don't think you can just completely ignore this and then just turn it over to your insurance company and say, here, it's your problem. I think you'll have a problem. It depends. It's all fact specific. And it's going to depend on what the vendor agreement's going to say. And it depends on what you're trying to do and how you're trying to do it. And is it willful or is it not? There's a lot of mitigating factors there. If you're trying, then I think that comes through loud and clear. If you're not, I think be prepared to get fined. And I think it's really that simple.
Well, and realize like this, I appreciate you all coming on and doing this session. And I know that this isn't like one of those sexy topics to be talking about, but at the end of the day, the dealerships work really, really hard to get, profit, to make money. And if like that, it can all go out the window. Then it is really important that we look at these proactive ways to protect ourselves. And I think you do. I think you're both right. I think we have to do a little bit of both. I think insurance helps us in what we don't know, because let's face it, there isn't any one of us dealers that really knows and understands all the nooks and crannies of it all. And then on the other side, that we're attempting and trying, and we are really trying to do everything that we can. Both those aspects are really important. But I want to talk to, two people right now. Vendors, if you're watching this and you know that you should be filling out a form and doing an assessment, please find out through, your channels, reach out to your people and say, hey, who in our organization is taking care of this? I'd like to let my dealers know, and have a proactive way so that the dealer knows who they're supposed to be talking to. That's if you're a vendor. If you're a dealer and you haven't started down this process, it is really, really important, because like they both said, if you're not at least showing that you're trying to do these things, and trust me, it's painful. We don't have time. This could be, a full-time job all day, every day for somebody to try to take on. But you have to show that we're at least trying. So figure out who that person is and make sure that they're both, at least we're trying to do both sides of this equation. And I think Brian hit it on the head, and Tom, you and I have talked about this before, and Brooke as well. Nothing's really going to change until the fines happen. And it's, and then it's going to have to be sizable, and then movement will start to actually go from there. But in the meantime, this idea of let's just keep ignoring this is not a good thing. I've worked for a dealer group that got a small fine for a situation years ago. And I will tell you that every person paid for that for years. Every person in the dealership paid for that for years in the form of packs and different things. So to think that this doesn't affect every single person who's currently working in a dealership, it does. Because if your dealer is the one that gets fined, it could be the loss of the dealership. It could be the loss of jobs. It could be the loss of income opportunity. So it impacts every single person in the dealership. And the ripple effect from there is that it will impact all of the vendors who, at this point are not partners if they're not trying to figure this out. So it does impact everyone, and it's time that everyone comes together to figure it out.
Let me follow on real quickly with that, April, because you're totally right. And something else everybody has to keep in mind is the reason that the FTC passed this is because of data breaches. That's the original reason. I mean, I don't know about you guys, but at least 4 times a year, I get the letter, and the letter says, we're sorry, your stuff has been breached and all that. So, and the best thing you do, in my opinion, is freeze your credit, and that way you're pretty good on that. But I would be remiss if we didn't talk about cyber insurance and what happens if there's a data breach. There's a dealer group up in Northern Virginia who's dealing with a class action lawsuit over this. This isn't just about the FTC fining you. This is also about exposing yourself legally to all of your customers. Now, the Gramm-Leach-Bliley Act in and of itself doesn't have a private right of action, which means if you have a data breach, George Jones can't sue you under the Gramm-Leach-Bliley Act. But what George Jones can sue you under is what's called the Unfair, Deceptive, Abusive Acts and Practices, or UDAP. And that's the statutes with which the lawyers are going to come after the dealers. And again, a lot of insurance policies will not cover those kinds of breaches. Your garage policy is not going to cover it. If you have a cyber policy, read it carefully. It may or may not cover it. And that doesn't include the reputational damage, April, which is what you were talking about, the reputational damage that you'll have for years to come. And the last thing you want to do is have to call your third generation customer and tell them, hey, I know you've been buying cars from my family since 1925, but we just put all your stuff out on the dark web and we're sorry you're going to have a problem, right? That's so there is reputational damage, which will impact the bottom line. And this is one of those instances where when somebody says, listen, I don't have time for compliance, I'm trying to sell cars, this is one of those things I say, listen, you don't have time not to do compliance because
Yep.
be a problem for you otherwise. And it's not an if, it's a when on cyber data breaches, right? I mean, the Pentagon, one of the articles during COVID is the Pentagon, they knew that Russia was in the Pentagon computer systems, but they couldn't figure out how to get Russia out of the Pentagon computer systems, right? So car dealers are not as sophisticated as the Pentagon systems, right? So it's going to happen.
Right.
To your point, is that this is something that I know you and I talk about a lot, is that the OEMs, this is not a bash and OEM segment at all. This is just a fact of the matter. OEMs are notorious for having they're not great at security. And this is just, it's well known. I mean, I post articles about this all the time, that just acknowledging that, hey, make sure that you've got things backed up. Make sure you're constantly looking at this, because it's, to your point, it's a matter of when it's going to be hacked and how many times it's going to be hacked. I just did an article recently about where your OEM is ranking on it, whether it's spying on your data, whether it's spying on your sexual activity. Like this, the stuff gets hacked all the time. And so, and to your point as well, is that most companies, especially in our industry, don't have enough cyber security insurance. So when it does happen, oh, by the way, do you know the cost of this and what it's going to cost you to back that up? So it is a matter of when.
That's vendors as well as dealers. I have vendor clients who have called me and I say, hey, let's start by looking at how much cyber insurance. They're like, well, why do I need cyber insurance? I'm like, because stuff rolls downhill. And these are all facts. These are all facts, not feelings, right? Well,
that's right. And Shift Digital for most OEM programs requires at least a $10 million, $20 million cyber security policy, and it's not cheap. I know the website providers all have to have cyber insurance. And Tom, you mentioned one thing about two things that dealers can do about really thinking about a customer data platform. I will tell you, I'm working on some very interesting projects, one for a very large dealer group. And in the future state, a year from now, all of their primary customer data will be in the CDP each night securely. And all vendor access really for marketing will completely change. For example,
it'll be a gateway.
Yeah. And it will be an interesting gateway, not a dump and pump. It would really be what I want to call real-time audiences. So in the CDP, we might create an audience of recent truck shoppers or recent service customers or lapsed service. In the past, Tom, they would take the dump from the DMS, email it over to their marketing partner. They'd run that list for a month. What they did with it, who knows? That's the scary thing. And then they would get another list. In the future state, the CDP will build a dynamic audience, connect it to Facebook, connect it to Google securely, and creative attached to that audience, meaning there will be no dumping of lists anymore. There will be basically a central hub where the customer will go through different states, move through certain marketing campaigns, which means that the dealer will know that the marketing company does not have access to PII, and that people who want or need access to the data, they can control that it's never through anything but a secure API and their functions. Now, that's going to be a long way off for the majority of dealers, but we are moving to a world where this exporting data from the DMS and CRM for marketing should be going away, and thankfully so. And that's going to be not only a better performance, but a better security. But, there's so many moving cogs in this that, let's put it this way, most people have no clue. They've never asked what you're doing with my data and how it's handled. And those conversations, whether we create a master list of all the companies that are currently transferring data that would fail the Gramm-Leach-Bliley Act, maybe do we have to do the public shaming list? At some point, dealers have to be protected because there's only so much an April Simmons can do, or, even our friends, Kevin Fry, or, Ryan Everson. Yeah, they're part of big groups, but they're just one voice that has no ability to move legal teams, no ability to move tech teams, no ability to move. But maybe if we make this a more public movement, that the OEM well.
And I love that, Brian. I want to piggyback your CDP because that's something I've actually started transitioning my vendor partners to. If they're unwilling to activate via my CDP versus my DMS or CRM, then I look for a different partner at this point. So I'm starting to make those moves, but the one piece I still have just besides the OEM, because they want to just use my DMS, that I'm having the issue with is, we're almost in a world where the purpose of a CRM is starting to be very minimal, right? And it becomes just the beginning communication. Like, so that PI information that is transitioning, that beginning piece, just for the hand raiser who says, hey, I need help, or here's my finance app, or those types of things, that's the part where we still have the need, right? That's where I still haven't quite figured out, like, marketing everything to the CDP, right? If it's marketing, it's after the first 3 days of the, then you're there. Like, because I can do a lot better job than I ever could in a CRM as far as marketing campaigns go. But there's those 2-3 initial days that we've got to work on and figure out.
Yeah. And one of the things that I don't know if we're going to get to without some massive disruption is, as I read the Gramm-Leach-Bliley Act, that simple website form on a dealer's website, it could be check availability, it could be my trade. What I do know, and most dealers may or may not know, is that like in a Shift Digital program, that lead form does not go to the dealer, right? So it goes to Shift. Shift is going to do something with it, some data hygiene, some data, but they're going to have a copy of that. Now, whether they need to roll up that data and send it to the OEM, whether or not they're sending that out for data modeling with J.D. Powers or Urban Science, but there could be a number of people who see that data that the dealer doesn't know. But the way I read the GLBA, the dealer's form has to disclose that by filling out this form, you are sending data to, and now the way I read it is you're sending it to the dealership, Shift Digital, I'm just to say it's Nissan Corp, and any affiliates. Like, who's going to really tell the dealer all the people who are getting a copy of that lead?
Right.
Yep.
That's why
And that's why it boils down to, we cannot, like, the dealer is the one ultimately responsible, but they're never going to know. So, fill out the form, fill out what sheets, and fix your stuff. Because once you sign that form saying you're compliant, I promise we're coming after you if you don't, right? Like, so that,
Yeah.
I think that's the gist of it.
It may be a case, April, that and I'm not the team at Shift Digital or friends. I'm just saying, if you're required to use, if a manufacturer by your franchise agreement saying you have to use Shift Digital as your digital marketing management company, and Shift Digital says these are the 5 website companies you can pick, and you have no choice, then I think the letter has to go to Shift and saying, since you're providing the platform and they are providing the data management, that's what Shift does, J.D. Powers, Unite Digital, they're just not picking website platforms. They are the data handling folks, rolling up reports. So it may be that your checklist has to go to Shift, not Dealer Inspire, because you understand Shift is the one that bills your parts statement, I think. Right? So from a vendor standpoint, Tom, you would have to chime in here, but dealers may not realize their website is contracted through Shift, not Dealer Inspire. And it's Shift who manages the data flow. And Shift knows all the parties that are getting that data, right? So it may be that Shift Digital will start to see more direct legal letters saying, I need you to document your the process by which you handle and supervise information that's entered on my website, and that all of that data is passed through the different vendors through secure channels. that will be the interesting thing. It will be interesting, April, to see how Schiff responds, because that seems to me the bigger win.
Mm-hmm.
The OEM requirement, and you can't choose. So if you can't choose and they won't respond, that's much better than Dealer Inspire not responding. Because Dealer Inspires is like, I don't contract with April Simmons. Schiff does, right? So there might even be a little shades of gray that dealers and dealers group may need to be talking to Unite Digital, JD Power, Schiff Digital about these GLBA compliance checklists.
I will give credit after multiple calls and emails. JD Power is got a check mark for me.
Okay.
So they are on my winner list. But again, the hardest part is just finding the person I'm even supposed to be talking to. That is the one thing that all vendors should at least reach out to your dealer and say, we're working on it. We're not ready to sign something, or here's the person you need to reach out to. Those things, that is the real time suck for me is I'm 100 emails per vendor just trying to find the person who knows what I'm even talking about.
Or I'll say, April, talking to you, and I've been on the other side, or my onboarding and any of my clients, I know they're having a little PTSD. They're like, oh, Brooke, your onboarding is atrocious. One of the question is who are you using for GLB compliance, and then how far into it are you? And a lot of times it's like, I don't know, or it's this. And for those that know at this point, like, it's great. But going into that, it's like, if April is reaching out to you, for the love, get back to her. Please get back to her. She should not have to, on top of every other hat that she's wearing, she shouldn't have to continue to chase you down. Get back to her. Like, why is it incumbent on you to chase and babysit every single else? Because either they're unaware or they just simply don't want to do it. Like, why?
Yeah.
Why are we having this conversation?
Exactly. And that's right now my biggest beef. I understand we're not perfect. We're not there. I mean, for Pete's sake, we're automotive. Of course, we're reactive. But at this point, just help get us moving together forward.
It's just, I said this, I think, Brooke, on one of the previous broadcasts, is if you're a vendor and you're watching this, task somebody with a monthly 2-paragraph update to send it to one person. You just send it to all your dealers and say, here's where we are. Think about the time that it's going to save the inbound phone calls if you're a vendor. Think about the time savings, and think about making your customer happy. You get both. It's a twofer for sure. You know, send a monthly email that says, here's where we are, here's what you're doing. Please add this to your binder and document that we're working on it. And that's all that has to happen. April would be very happy if all 50 of her vendors did that, because then she'd just say, okay, drag and drop into this folder and drag and drop into that folder, and I'm done. So, and let me also mention that one of the positive things, and this is not my area, but I can just see this from having all my dealer clients, is the GLBA has kind of forced a conversation about who owns what data. And there are a lot more people who are a lot better at this topic than me. But if you don't own your data and you're not controlling your data as a dealer, that's your asset. So when you go to sell, if you have control of all your data, I think that's a huge feather in your cap. At number one. And number two, you don't want some of these vendors selling your data to third parties. So as a part of all this, taking control of your data, I think, is a huge thing to consider in trying to move forward and try to do so with positivity.
Amen.
Well,
all right. Before we jump in the lightning round, any other parting thoughts? I know we've covered a lot in this time period. I know it's a much needed topic. Anything that we left out? I'm going to start with April, because you and I started this conversation a couple months ago. We're like, hey, we need to jump on this again. So I'm going to start with April, go up to Tom, and then over to Brian.
Just reiterating that this is obviously a marathon and not a sprint. And we all just need to at least get up to the starting point and start that marathon today.
Awesome. Tom?
Document. If you don't know how to document, then I'm going to suggest this. Go to your printer and have them type at the top of the form that says report of discussion and have pads of them made. And on that report of discussion form, you put, I spoke with, colon, and a blank, at this time, and a blank. We discussed blank. And if you have those on your desk, every time you have a discussion, you can write one, stick it in a folder, or digitally upload it, or however you want to do it. If you have the documentation, you're going to be happier if anything happens.
I'm a big fan of that. Brian, down to you.
Sure. One of the benefits of starting a CDP project is documenting where all your data comes from and who is utilizing it. So if dealers who are watching don't really understand what a CDP is, go to paschgroup.com, download that research report. And then this November at the Modern Retailing Conference, we're going to have a rapid fire discussion on CDPs. And I'm thinking, Tom, we should really add some GLBA sauce into that mix. But if dealers really want to see what tech solutions are available to help protect me in the future from first-party data management fines, CDPs could be the answer, and MRC is a good shopping place.
I agree with that one. I agree with that. All right, ladies and gentlemen, we are now jumping into lightning round with our awesome guests here. We're going to start, we'll start with Brian, because we started with April last time. We're going to start with Brian here. Brian, we're going to first start with how can everyone get in touch with you? As you can see, it's like below your face, below my face and your face. We've got your personalized link here, but for those that are listening, how can they get in touch with you? How can they find you?
Sure. The easiest way to connect with me on LinkedIn or email brian@brianpasch.com. It couldn't be any easier. Either way, let's talk.
Fantastic. April, over to you. You've got your personalized link right below your beautiful face, but how can everyone get in touch with you? How can they find you?
LinkedIn is usually the easiest, or you can always reach me at my email, which is april@horne, HORNE, cars.com.
Fan-freaking-tastic. And Tom, there we go. Couldn't say your name there, but we got there. How can everyone get in touch with you?
Well, you can go to my website, bettervantagepoint.com, fill out a form. You can go to my website and hit Video Connect with Tom now, and up you'll pop on my phone where we can chat. You can send an email to me, tomk@bettervantagepoint.com, or you can call or text 757-434-7656.
A lot of ways to get in touch with you. Tom, we're going to stay with you because we're on your face right now. Name of the show was Facts Not Feelings. How are you distinguishing facts from feelings?
How am I because that's the world I live in. You and I live in the same world. When we're talking about risk at a dealership and trying to talk about compliance, we're always going back to what are the facts of the situation. When a dealer gets sued, we have to get to the facts first, right? You've always got to get back to those facts. Otherwise, you're building a house of cards. So, I subscribe to Facts Not Feelings, and because that's my business too.
Fantastic. April, over to you.
The biggest thing, facts not feelings for me is facts is your feeling validator, right? We all have gut feelings. We all get feelings. And no matter whether we're talking about marketing or we're talking about communication one-to-one, I always say, okay, this is what I feel. Now I need to validate it with a fact. It's either yes or it's no, but it's always based on logic, which is where fact remains.
Fantastic. Brian, over to you.
I would say it takes time to control your feelings. Early in this automotive business, I might rush out and write some things and stir the pot based on feelings and hope that the facts align. This weekend's article on Cap One, a couple of people said, well written, well supported. And I think as you mature, you realize people respect people who have the right balance of emotion backed up by facts. If you're too leaning on hype and emotions, over time, people grow tired. People will never grow tired of passionate people who are speaking factual truths.
Ooh, I like that one. All right, Brian, I want to start with you again and round this out with what is something that's maybe a hidden talent or something that I'll say the majority of people might not know about you.
Ooh, okay.
Mix it up here.
Okay, sure. I was a high school physics teacher.
Wow. Okay. All right. I like it.
There we
I
go.
like it.
I'm an avid boater, sailor. I love spending time on the water. When I was a young thing, I got my Captain Coast Guard license because just wanted to have it. And they liked me so much, they asked me back a second time to take the test to make sure that I was going to do it properly. And I did that and really enjoy being on the water. I've owned 14 boats, 15 boats in my life. So, because I was a car guy, so sell and buy and trade and whatever. So that's not something that I talk about regularly, but when I can, I like being on the water.
Fantastic. All righty.
Okay, so yeah, I'm going to piggyback that a little bit because a lot of people don't know that I'm really not at all a girly girl. I kind of look like a girly girl, but I do enjoy being outdoors very much. I take trips as much as I can to get out into nature. But one that people probably don't know about me is that when I was younger, especially, I was a really, really good bowler. And I have a slew of bowling trophies to prove it.
Okay. Nice.
All right.
Okay, there we
That's
go.
a great
I like
one.
it, I like
That's a good one.
There we go. All right. All right, everyone. You know the drill at this point. Thank you so much. I so appreciate everyone on this. This was such, I know we've done a few shows on this, but this was such a needed topic. And April, thank you so much for reaching out and being like, hey, we got to talk about this again. So I just so thank you for that so much. And everyone, as always, find a way to serve today. Find a way to just help. And whether that is a kind smile, whether that is opening a door, just find a way to serve today. And with that, everyone, we will see everybody next week.